Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happenings Today YouTube channel. Of course, the matter has been adjourned to May 19, but a lot of things transpired within the court premises. That is what reported. One of such is the fact that Peter Obi lawyers have started lamenting over the little tricky way INEC is going about this issue of evidences, and they have made their mind, they've made up their mind to open it all up. Of course, APC lawyers were there to, so to speak, should I say, refute. You're going to, in a moment, you're going to find out that. And also the issue of televising the whole process. They have decided to counter it. Of course, the likes of APC and INEC join forces together to have a counterclaim on that. We're going to give you all these full juicy details into one and very quickly too. Before we do that, kindly subscribe to our channel. All right, according to the news, Levi Onyeukwo, the counsel to Peter will be complaining to the tribunal today that his team is yet to get more than 70% of the documents from INEC and other parties, especially documents from Rivers State. This is despite INEC's chairman's promise to make the documents available. The document requested include result sheets from polling units and documents used to register voters. It will be recalled that Obi's petition was adjourned to enable all parties identify documents to be objected to or not. When Justice Haruna Samani asked Wole Olanikpekun if he has identified his own document, he said, "Well, I don't want to talk before him." That's Levi in respect of that. The question is, why don't you want to talk before him? Do you already have your own document? Of course, in another news, very quickly before we go into the analysis. Well, in another news, very quickly, the president-elect Bola Tinubu and the vice president-elect Kashim Shettima have urged the Presidential Election Petition Court, otherwise known as PEPC, to dismiss the application by Atiku Abubakar and the People's Democratic Party (PDP) for a live broadcast of proceedings. Tinubu and Shettima described the application as frivolous and a bid to waste the court's time. Besides, they said the court is not a soapbox or a stadium or a theater where the public should be entertained. I quote him word for word, said, "With much respect to the petitioners, the motion is an abuse of the processes of this honorable court," the respondent stated in a joint response filed on Monday by their team of lawyers led by Chief Wole Olanikpekun, Senior Advocate of Nigeria (SAN). They wondered why a petitioner desirous of a prompt hearing would file an application intended solely to distract the court and waste its precious time. They urged that the relief sought by the applicants are not such that the court could grant. They stated in the counter affidavit that the application relates to policy formulation of the court, which is outside the PEPC's jurisdiction as constituted. The application also touches on the powers and jurisdiction invested in the President of the Court of Appeal by the Constitution, over which this honorable court, as presently constituted, cannot entertain. I quote him word for word, said the application touches on the administrative functions which are exclusively reserved for the President of the Court of Appeal. The application is aimed at dissipating the precious judicial time of this honorable court. The said application does not have any bearing with the petition filed by the petitioners before this honorable court. It is interesting, or better still, it is in the interest of the justice for this honorable court to dismiss the said application filed by the petitioners, they said. In an attached written address, the respondent faulted the applicant's reference to the fact that visual proceedings were allowed during the COVID-19 pandemic. They urged that Atiku and his party failed to draw the court's attention to the fact that practice directions were made by the respective courts for the exercise. They also noted that it was only the heads of court rather than individual judges or justices who drafted the practice directions. Another angle to this very curious application is the invitation it extends to the court to make an order that it cannot supervise. The position of the law remains, and we do submit, that the court, like nature, does not make an order in vain or an order which is incapable of enforcement, the respondent stated. Tinubu and Shettima added, at the very best, this application is academic, very unnecessary, very time-wasting, most unusual and most unexpected, particularly from a set of petitioners who should be praying for the expeditious trial of this petition. Petitioners have brought their application under Section 36, subsection 3 of the Constitution, which provides that the proceedings of a court or tribunal shall be held in public. The word public, as applied under Section 36, subsection 3 of the Constitution, has been defined in a plethora of judicial authorities to mean a place where members of the public have unhindered access and the court itself sitting behind open doors, not in camera. Even in situations where a class action is presented, the particular people constituting the class being represented by the plaintiffs or petitioners are always defined in the originating process. Here in this application, the public at whose behest this application has been presented is not defined, not known, not discernible. Beyond all this, it is our submission that the court of law must and should always remain what it is, what it should be, and what it is expected to be: a serene, disciplined, hallowed, tranquil, honorable, and decorous institution and place. It is not a rostrum or a soapbox. It is not also a stadium or a theater. It is not an arena for public entertainment. With much respect to the petitioners, the motion is an abuse of the processes of this honorable court. Also, in its counter affidavit filed last on Monday, the Independent National Electoral Commission (INEC) raised similar arguments and prayed the court to reject the application by Atiku and his party. You have seen it all. You have now seen the technical things that are using to play in this whole documentation process. A typical example is what Levi, one of the representative of Labour Party lawyers, is saying. Look, up till today, up to the time where they give them 1 week to get all the necessary documents they will be objectable to, and when they will accept and all that, INEC should make those documents available. Labour Party and Peter Obi's lawyer are yet to get 70%, especially that of Rivers State. They're yet to get. But they asked at the APC lawyer, have you been able to get your own documents, since they gave all of them, all the parties involved, equal time to do same from INEC? And they said that they wouldn't want to join issues and make issues with Levi. The question is, if, I'm just assuming, if APC had gotten the document in the same vein, what stops Labour Party and Peter Obi's lawyer from getting same? This election took place the same time, the same day. I don't see any reason why they're still having difficulty up till now. Talking about a May, for crying out loud. This happened in February 25th. We shouldn't be discussing this till now. These technicalities now do not look as if Peter Obi's lawyers are not prepared. Who says they got all their documents? INEC released the documents now. Let's go wrap it up. You've heard it all. They said they don't want the issue of televising. They're countering it with every muscle and technicality they've got. Let's go wrap it up. Let's meet in the conversation.